thing that I'd like to start with is oftentimes people think these are two different laws, and in fact, they are not two different laws. CPRA's origins are through a proposition ballot in California. So this was Proposition 24, which was passed, and it is an amendment to the CCPA, not a new law. So they don't compete with each other. These are, depending on your point of view, enhancements to the current CCPA law. There are a bunch of things, though, beyond its origins that are different. And let me just take just a minute or two to kind of review some of those. In terms of major differences, the CPRA now has obligations to do privacy impact assessments against high-risk processing. It's revised the applicability qualification for businesses. So what's changed is that in addition to potential revenue size or money that you generated from the sale of data, the CPRA now has increased the parameter of buying or selling consumer information from 50,000 people to 100,000 people. And the purpose of that really was to sort of alleviate the burden on smaller companies from having to comply. They're trying to make this an easier law to comply with. In addition to the applicability, there's increased categories of what's considered sensitive information. Affirmative consent is required for sensitive information, including and specifically around the use of children's information. Consent is required for the sale of sharing personal information if somebody wants to opt back in after they've already opted out. It's required if you're asking for participation with some sort of financial incentive in return for the data. It's also required now for additional uses than were originally described or consent was given for. And then lastly, I think I said this already, but for sensitive personal information. CPRA also comes with increased rights beyond what CCPA originally allowed for. And now that includes rectification or correction. It allows for the opt-out of sharing data for cross-contextual behavioral advertising, or for the use and or disclosure of sensitive information. And then lastly, you have a right to opt out for automated decision-making. And then quickly, a few other things. CPRA now includes obligations for contracting your downstream vendors to make sure that they're abiding by the same privacy and security practices that you're committed to. Risk assessments are now, as I think I mentioned that earlier, are now required for high-risk processing. CPRA comes with a private right of action. It's in a limited context. It's about if there's a data breach and you don't have the appropriate security protocols in place, then private right of action would be applicable. And then right now, CCPA has a 30-day cure period. So if you were tapped for a violation, you have 30 days to fix it. Under CPRA, that cure period is going to disappear.